Well, thank you for inviting me today to talk to you a little bit about Ontario's Brownfields regime. In the intro, John mentioned that I'd been at the Ministry of Environment for 8 years. I was there as a lawyer for 8 years, and I also articled there. And basically, Ontario's Brownfields regime. I remember when I started at the MOE, I worked with lawyers who were drafting the Brownfields Amendment Act and the first version of the regulation. And here we are 10 years later with a different version and well, a more comprehensive version, and I'm simply going to give you a background to all that and tell you, one takeaway message, which is if you intend to file a record of site condition for your property on the ministry's website, or you want some protection from the ministry issuing an order to clean up a property, then you need to follow the current regulation 15304. So let's get right into it. There we go. So yeah, overview. I'll go through a brief chronology of the regime, brief overview of the major changes to the regulation. Corey, who's up after me, will be giving a presentation, a more detailed technical presentation on the Phase 1, and I will keep this to a bird's eye view overview. Overview of changes to the standards, and then I'll point you to some relevant resources from the MOE for more information. So, what is a brownfield? How did all this begin? We go back to the 1980s, need to clean up refinery lands in Oakville and Port Credit, which have since been redeveloped or are in the process of being redeveloped. Ministry needed to figure out, well, to what standards did remediation need to, soils need to be remediated to, etc. There were guidelines issued in 1989, and then those were subsequently revised in 1993. And then many of you may be familiar with the 1996 guideline for use at contaminated sites in Ontario. You can still find it on the internet, and the one I have is the February 1st, 2007. But that guideline contained standards that were applied for Phase 1 and Phase 2 assessments, risk assessments, all that stuff. It was used all the way up until October 1st, 2004, when the new soil standards came into force as a result of the Brownfields Amendment Act, and assessments that were done prior that did comply with the 96 cleanup guideline are still referred to in the transition sections of the current reg. So, if you did it under the old ones back then, you could still be protected somewhat from certain orders. Okay, so as I mentioned, 2001, November 2nd, 2001, the Brownfields bill received royal assent. The ministry took about a year and a half or so prior to that to draft it and come up with it. And the significant things it did is it added Parts XVI, records of site condition, and XV2, protection for lenders, to the Environmental Protection Act, as well as the amendments necessary to other acts like the Municipal Act, etc., Planning Act. And then the amendments actually came into force at various times between 2002 and October 1st, 2005. Okay. In 2004, most sections of the reg, and the regulation is the document that contains the nitty-gritty details of what needs to be done, and it's Regulation 15304. They call it Records of Site Condition, and most of the sections came into force October 1st, 2004, and it was subsequently amended a bunch of times between 2005 and 2011. The significant amendments were announced, well, in 2007 the government announced that it would do comprehensive reforms to the regime to make the site registry more transparent, to strengthen the standards, to redefine who a qualified person is, et cetera, et cetera. So the announcement came in 2007 after 2 years of work with various stakeholders. The reforms were filed as Regulation 511, and some consultants today refer to a 511 Phase 1 or Phase 2 site assessment as opposed to a 153, and I'll get into that a little later, and I'm sure Corey will as well. So the reforms were presented in this Regulation 511. It's 87 pages long, lots of reforms, and subsequently there were some tweaking amendments, further amendments made to it by 3 more regulations, and that brings us up to today, 2011. Reg 153, with all its amendments, is in force, with the exception of those dealing with environmental compliance approvals. For those of you familiar with environmental law in Ontario, there's things called certificates of approval. The ministry undertook a process over the last 5 years or so to modernize their system. So starting October 31st of this year, that new system will come into place. It's called, for simple things, people will just get environmental compliance approvals, and it's supposed to be much more streamlined, etc. Where the reg mentions necessary certificates, they now just change the name. So, all right, so that was the regulation, and the regulation sets out the requirements to do Phase 1, Phase 2, risk assessments, all that stuff, and it refers to standards, so the actual numerical standards that the soils, etc., have to meet. So you can't have contaminants based on how clean your site, and I'm not going to get into that, but the standards are where you find the numerical values that you have to meet for the particular land use you want your property to meet. And I forgot to mention this before. The reason to get an RSC is if you want to change the use of your property from a less sensitive use to a more sensitive use. Okay, you need to meet the numbers set out in the standards. So I mentioned earlier the standards were contained in the 96 guideline. Then in 2004, the ministry put them into the soil, groundwater, and sediment standards. These were in force from October 2004 to June 30th, 2011. If you're looking around on the internet, you'll notice that there's another version of the standards dated July 27th, 2009. That was posted, but it was never in force. And the current standards are the ones dated April 15th, 2011. So, very brief overview of the major changes. One thing you notice is pre-July 1st, the reg was 45 pages in length. It's now 110 pages in length. I'll just go down the post-July 1st column because that's what, unless you fall within the transition provisions, okay, if you're starting off today, you need to follow the reg as it is today. And so it's got parts 1 to 12. 12 deals with soils. And I just highlight the reg now in part 7 spells out what is required for a phase 1 ESA, and it used to reference the Canadian Standards Association code Z76801 for phase 1, Z76891 for phase 2s. So a major change is that the reg now has no longer refers to those CSA standards. It sets out explicitly in the reg itself what is required for a phase 1 and a phase 2. So I list that here, Schedule D. So Part 1 of the reg is about 5 or 6 pages long. It describes for phase 1. The details are provided in about 10 more pages throughout Schedule D. The application, records review, interviews, site reconnaissance, review, evaluation of information, report. And it provides 2 tables. Table 1, mandatory requirements. Table 2, potentially contaminating activities. And then it does all the same for phase 2s. And finally, Schedule F sets out requirements for soil. And this is for soil brought back to a property, I believe. I'll let Corey deal with that if he likes. I just want to give you the overview. Okay, and then just an overview of the changes to the standards. The 2004 standards had 6 tables. 2011 standards has those, oh, there's a little typo there. It should say tables 1 to 5 are the same, except with various changes in the actual numerical values. Table 6, the idea is the same, but the title's changed to generic condition, site condition standards for shallow soils in a potable groundwater condition. And then tables 7, 8, and 9 are new tables that have been added to the 2011 standards. So, in summary, if you want to change the use of the property from less sensitive to more sensitive, or if you want protection from MOE orders, you must file a record of site condition. In order to file the record of site condition, if you're not subject to the transition provisions, meaning you started your project before and you actually sent a notice to the MOE saying you'd like the old standards and reg to apply to you, you get an extra 18 months, I believe, to use it. But if you didn't do that, and you would have had to file that notice prior to January 1st of this year. So you had until December 30th of last year to do that. If you didn't do that, then you're subject to 153.04 if, again, you want to change the use of the property or want protection from MOE orders. And third, major change, requirements for phase 1 and 2 now spelled out in the reg, no longer reference the Canadian standards documents.